Hi, I'm Tricia Dunlap, a small business attorney with Dunlap Law in Richmond, Virginia. I'm here today to talk with you about limited liability companies, also known as an LLC. These are incredibly popular business entities that are very easy to form. They're inexpensive. You can go right to the Virginia State Corporation Commission website and fill out an online form and pay your $100, and boom, you've got an LLC. Because they are so easy to form, many people seem to be under the belief that there's not a lot of risk. And this video and my accompanying blog series is here to educate you about some of the risks in being a member of an LLC. So stay tuned. First of all, let's talk today about LLC minority members. That's what the people who own an LLC are called. They're called members under the law. And anyone who is a minority member of an LLC, meaning that you own less than 50.1% of the LLC, has some special risks that they really need to think carefully about. I have a blog series about this on my website with a special post devoted to the perils of being a minority member of an LLC. So you want to be sure to check that out. In this video, I'm just going to touch on 3 of the most basic things that you've got to think about if you're a minority member of an LLC. Number 1, will your ownership interest be diluted in the future? Let's say that right now you're a 30% owner of an LLC and there are 3 other members, so there's a total of 4 of you. And someday in the future, you are hoping to add additional members or to perhaps bring in some investors whose capital will help you grow the business. Well, those investors or those additional members are going to need a slice of the pie. That means that they're going to need a piece of your 30%. One of the most important things to consider in being a minority member is whether or not your interest will be diluted equally and evenly with the interests owned by other members. If this isn't spelled out correctly in an operating agreement that protects your interests, then you could risk being diluted in your membership interest and having your value diluted in ways that are not equitable with the other members. That's one important thing to consider. A second important risk to consider is whether or not you and the other members of the LLC will owe one another and the LLC fiduciary duties. Fiduciary duties are things like the duty of care, which means that anybody making decisions on behalf of the LLC needs to be careful and thoughtful in how they make those decisions. They need to gather information. They need to talk to experts such as lawyers and CPAs before they make business decisions. That's the duty of care. Also, there's the duty of loyalty. Will you and the other members of the LLC be required to act in the best interests of the LLC at all times? Or can you engage in self-dealing? Can you perhaps engage in conflict of interest transactions? Can you put your interests above the interests of the LLC, or perhaps even have a competing business that competes with the LLC? If your LLC's operating agreement doesn't clearly spell out that there's a duty of loyalty to the LLC, then this will not apply. Finally, there's the duty of good faith, which means that everybody acting on behalf of the LLC needs to be fair, honest, and honorable in their dealings with one another. I know that's a quaint idea, but honestly, an operating agreement carefully drafted for an LLC can impose all 3 of these fiduciary duties on members, either in how they engage with one another or in how they engage with the LLC, or both. So fiduciary duties are an important consideration. And then finally, the third thing I want to talk about today are what are called capital calls. A capital call is if an LLC is perhaps running out of money and it needs additional capital from its members in order to keep operating. Depending on the terms of an LLC's operating agreement, a capital call could be mandatory, which means that if the members vote or the manager calls for additional capital, you have to contribute it. What if you can't? or you don't want to? Well, you might lose your voting rights. You might lose your right to a distribution from the LLC in the future. And you might also find that your interest is diluted. So how capital calls are managed are an important consideration that should also be addressed in an LLC operating agreement. This video is just one of a multi-part series on LLCs and all of the risks that are possible in an LLC. I highly recommend that if you are in an LLC or you're planning to be a member of an LLC, that you look through all of these videos and read the blog posts. We're here to help you if you need some advice. It's not just about having an operating agreement drafted and in place. It's about getting the right counsel from a good lawyer who can help you protect your interests. I'm Trisha Dunlap with Dunlap Law in Richmond, Virginia. Give us a call if we can help. And as always, like, subscribe, and share this video. Thank you.